said you had a couple.
Yeah.
Where's the off button?
Right here's the off button. And it's gonna take 2 seconds. Power up.
Okay, we'll put it right there.
Anything else? Yeah.
That was it. That just got shut off.
So, Dr. Young is here today to do the competency evaluation, so in order to be able to see him and participate in that evaluation without any preconditions placed on it by you.
Well, with all due respect, I would like a lawyer now. My lawyer hasn't done her job yet. She put in a fraudulent mental health report, and she's refused to confront her error to the court.
We're talking about the competency evaluation right now. You filed more things today.
Yeah.
Despite the court telling you not to. You filed things in the past. It's pretty clear you're recording things in the courtroom as well. And so I'm not going to let you do that at the evaluation.
Now, what is the law pertaining to recording?
You need to self-control. This is a court order for you to participate in the evaluation just like everyone else. So you have 2 choices. You can go there right now and meet with Dr. Young and participate in that evaluation fully and completely, or you can be held in civil contempt for violating a court order and be taken into custody. And you will remain in custody until you can purge yourself of that civil contempt finding by notifying the court that you will participate in the evaluation.
I participated in the last one. He's the one that refused to do it.
Well, no, you didn't, because you put a precondition on it which you were not allowed to do.
Well, with all due respect, if he's going to provide evidence, I have the right to defend myself.
What's your choice, civil contempt or go see Dr. Young?
I'll go see him. I seen him last time. He refused to do it. He supplied a faulty report to begin with.
So the court officer will escort you to the room, you will stay there, and you will participate as you're supposed to.
Yep.
All right, and then you'll be brought back here, so I know that you've done that, and if you haven't, you'll be in civil contempt.
Is it possible to get a lawyer first? She's not a civil lawyer.
Come down to the court officer, without your phone.
Elevator or the stairs?
I'll take the stairs.
All right. Go ahead.
Just one, you take so.
10-4. Second. Thank you. He's on his way.
Oh, you got,
We're going to get him.
oh, you're going to, right there.
Right in here.
All right, is it possible to get a witness here?
Yep, you got a GAL right there.
Well,
All right.
with due respect, she's illegally appointed in her case.
She's what?
Illegally appointed in her case.
She's legally appointed?
Illegally.
Okay, who are you going to... Look, the judge said no on the lawyers, okay?
That doesn't mean I can't have a witness.
Right. Who are you going to have for a witness?
Give her.
Actually, I can have anyone I want as a
Are you
witness.
supposed to give him the?
Give me your phone.
The phone.
I'm not going to play your games. I'll bring you back up to the table.
Oh, with all
okay?
due respect.
Please go in there and have a
Violation of
seat
Fifth
and
Amendment.
wait, okay?
So, the way I usually start this, and we've gone through this maybe a couple times previously, is I kind of go over with you the purpose and conditions of examinations. This is the kind of thing I do with everybody that I work with. And so, what I'm going to do is put your name here. Is your date of birth?
May 7th, 84.
May 7th, 84. Okay. So these are the exact same. I usually ask that folks sign after we've reviewed all these things, so I make sure they have an understanding of what this evaluation is all about. So let me go ahead and, if I recall, you know how to read, right?
Yep.
Not everybody I evaluate knows how to read, so sometimes I just go through this with them. But these are the same, except one I usually request that we sign for the purposes of documentation. So if you want to read with me, I'm going to start up your evaluee's name, and I put your name here,
Yep.
Joshua Norton. The evaluee has been informed of the following, and then number 1, I'm a psychiatrist who's been appointed by the court. Number 2, the purpose of this examination is to perform a psychiatric evaluation that will provide information to the court. Number 3, my interaction with you is not intended to start a customary doctor-patient relationship. As such, I will not be providing you recommendations about treatment, prescribing you medications, or providing other treatment, or planning to follow up with you in the future, although that does sometimes occur. Number 4, I plan to prepare a written report that will be forwarded to the court that will contain information obtained from you and probably from other sources, for example, other people or medical records or other reports that have been done before, and therefore will not remain strictly confidential. Number 5, various people will review my report, including the judge, the prosecuting attorney, your attorney if you have one, primarily those people. Number 6, the court may request that I testify about you in the future, such as a deposition or sometimes a trial. Number 7, your participation in the examination is voluntary. You can take breaks if needed.
I was just forced into it.
Okay, we can talk about that. You can terminate the interview at any time if you wish, and I'll complete a report and submit it to the court regardless of whether you participate in the interview or not. So it's tell me any questions about what I went over.
Are you aware that I don't have a lawyer at this time? I don't see a lawyer sitting there.
Right. So you do not have an attorney right now? Okay.
Yeah.
I have never interviewed somebody like this with an attorney present.
Well, why not? You can write whatever you want in your report. It doesn't make it true.
No.
We're dealing with a conflict case involving injuries. In turn, that in fact has a civil side to the case.
Yep.
Yeah.
It could, I guess.
It does.
Yeah. Usually my information report goes to the criminal side, usually the criminal part of whatever case there is. There's a civil side that's kind of different, and that usually doesn't pertain as much.
Well, due respect, according to law, you're civil party evidence right now. You're presenting me civil party evidence prior to a hearing.
Okay.
That means you're going to give evidence back to the court on anything you ask.
That's right, yes.
Yeah.
So it's for
without them acknowledging evidence prior?
Yeah, I don't know. I don't understand that. I don't know exactly what that means exactly.
In federal law, it can be considered a conspiracy against rights.
Okay.
The state has the burden of providing, beyond a reasonable doubt, guilty or not guilty in the charges.
Right, that's my understanding.
Yeah.
Okay.
And we have not received evidence yet.
Okay.
So what am I testifying to you for?
You're not testifying. This is an evaluation, psychiatric evaluation that is designed to help the court understand whether that might be something to take into consideration. The main reason I'm being asked, the court order that I have, is to evaluate you for competence to stand trial. In other words, does a mental health condition impact your ability to fairly and fully mount an effective defense, so that you
I've
can be
already
treated fairly?
supplied information to my attorney. The cross-reference and the downside to that is it applies against the state. I understand the state has a couple problems or not wanting to acknowledge it.
Okay.
However, there's a substantial amount of damages done.
Okay. Well, what I'm going to do, my plan is to, here's the way I usually do this. Let me just tell you what I do, and then you know, again, this is voluntary. It's voluntary as far as I'm concerned. That there's usually a court order, and that's something that tells somebody that the court is ordering that they get the evaluation.
So would you have a problem doing this in writing? Any questions you may ask?
What do you mean?
Well, if we're digging, no offense, if we're digging into any information related to the case, I'm entitled to have defense to protect my rights and my Fifth Amendment violation. Technically, this could be construed as a Fifth Amendment violation.
Yep.
So,
Your GAL's here, would you like her?
no, actually, I'd like an additional witness, or, well, she can come in if she wants.
Thank you.
However, we may have problems with her too, so.
Okay. So,
The first report that was ever actually put in was rather inaccurate, so technically, she's illegally appointed in her case.
okay. So, again, my intention is to do a psychiatric evaluation. What I tend to do is start with a person's, ask them a little bit about their personal history, ask them about their medical history, if they've ever had mental health issues, et cetera. I go through that just to get an idea about you and your background and your history. I usually then go through and ask questions about court and court proceedings to see if, just to kind of get an idea whether you grasp, basic courtroom terminology, or
So would you care to do it in writing?
I don't do it in writing. I do it face to face and.
You got a problem if I answer all your questions in writing?
Yeah. I mean, I can't.
So what are we doing here?
I don't know.
With all due respect, you can write whatever you want in your report.
Well, I don't write whatever I want in my report. I follow the facts. I try.
Last time you were given information
Yeah.
pertaining to the case, and you wrote the exact opposite.
Well, which information?
See, we can't actually go over there. We're digging into the case now, which entitles me to a lawyer. So you can ask your questions.
Okay. So what I rely on is having an interview where we talk to each other.
Yep.
So you agree to participate in the evaluation at this point?
I would prefer a lawyer here, which I
Okay.
do not have.
Okay.
And I was just forced into this.
Okay. Well, from my perspective,
I'm participating against my will. I was just told to participate by the judge.
okay. Well, the participation, from my perspective, is voluntary.
Well, actually, I was just dragged down here involuntarily.
Okay. It's
See,
so
if
this,
you were
this is up to you. If you want to do this evaluation, it's up to you. There may be
I was
consequences.
just told I was in contempt of court
Okay.
if I didn't. So that's what I will say. I was held in contempt of court if I failed to do the evaluation. So therefore, I am participating.
Okay.
Would you like me to write that down?
What I do is you can write, you can add something on there if you want, and then you can.
And I need a copy of this.
We can see if we can get you a copy of it before you leave. But the bottom line is, this is you have a choice on whether to participate in the evaluation with me.
The judge just actually violated the 14th Amendment of the United States Constitution by actually saying this.
Okay. Your participation, in the end, is voluntary. There may be consequences to not doing it, but that's not really is not part of what I'm concerned about. I'm just trying to get information and try to learn a bit about you, and so I can be helpful to the court.
Well, with all due respect, we're running into issues here. We can talk about it. 17/2015.
My name is Rita Reinhardt, R-I-T-A, R-I-N-E-H-A-R-T.
R-I-T-A-R-I-N-E-H-A-R-T. Okay. And you're guardian ad litem?
Yes.
Okay. I typically don't ask questions to other folks in the room other than the person who I'm being asked to evaluate, but I like to document
I'd like
his
to know
presence.
who.
Yeah.
I will need a copy of this, right?
I will try to make a copy before we go, if you'd like to. The other thing you could do is, if you'd like to write down. I don't know, I don't have a copy machine here, but they do downstairs. I think there's a chance we could get a copy. An alternative is you could write down the exact same thing on each of these, and then keep one for yourself, and we could.
I'd rather have the direct copy.
Okay, we can try to do
And
that.
I already know they have a copy machine because we've been down this route before.
Did we do that last time,
We did.
like in December?
Whenever the valuation was, we did.
Okay. I don't recall. So, okay. So we'll have that here. We'll make a copy. We'll try to make a copy. And okay. So I usually like to start